Yes, Your Honor. May it please the court. Opposing counsel. Ladies and gentlemen of the jury, I don't know how many of us are fans of kids' movies, but if this trial were a recreation of Alice in Wonderland, Officer Kevin Bates would be the Queen of Hearts. At the slightest irritation or annoyance, his first response is, off with their heads. You see, we've learned from the evidence in this case that my client, Andy Madison, a student at Street Law High School, was enjoying an early day off from class to celebrate the Thanksgiving holiday. We've learned that he was lawfully on school grounds with his friends when they were approached by Officer Bates, who sternly demanded that they produce ID. And we've learned that when my client attempted to produce that ID, apparently not fast enough for Officer Bates' liking, that in less time than it takes for me to finish this sentence, Officer Bates thought he saw something shiny protruding from my client's back pocket, concluded that it was a knife, and grabbed my client by the arm to place him under arrest. In the process, twisting his arm behind him with such aggressive force that he snapped Andy's wrist in two. Now, like Alice, the prosecution wants you to fall down the rabbit hole and convict my client based solely on the fact that Andy's not perfect. His disciplinary history is in the record. It's there for all of us to see. We would have stipulated to that. But if we're going to consider the disciplinary history of Andy Madison, wouldn't it only be fair for us to also consider the disciplinary history of Officer Bates? This grown man has numerous civilian complaints against him, the most recent of which was only months before the confrontation with my client. And it's not just frivolous things that someone might expect from a criminal who was caught red-handed and wanted to get back at their arresting officer. No, ladies and gentlemen, the police department has actually had to warn Officer Bates that his use of force was excessive. And if that wasn't bad enough, do you know what makes it worse? Do you know what separates Officer Bates from my client? Andy's just a kid. He hasn't even graduated from high school yet. Officer Bates has graduated from high school, has graduated from the police academy, has graduated from numerous required courses on how to engage the community, how to use force, and when that use of force is excessive. Now, the state wants to take your eye off of that, so they had his partner testify with her Cheshire Cat grin that my client used bad judgment. And if this were any other trial, I'd say, yeah, that was possible. How many of us haven't used bad judgment when we were in high school? But the evidence tells us that didn't happen. And more importantly, the United States Constitution guarantees all of us the presumption of innocence. That means the state must prove beyond a reasonable doubt each and every element of each and every crime with which my client has been charged. Andy's been charged with assault, and yet we have heard zero evidence of any kind that Andy ever threatened Officer Bates, either verbally or through making a threatening gesture. He's been charged with battery and with assault on an officer. Both offenses require that he have caused a harmful or offensive contact with Officer Bates, and yet the evidence tells us that didn't happen. What evidence was that? His student ID card being found on the ground when the scuffle was over. Now, did his ID magically levitate from his back pocket and fall to the ground? Of course not. Even in Wonderland, gravity only works in one direction. What the evidence tells us is that it was the ID card that my client was grabbing. It was the ID card that reflected the light of the afternoon sun that Officer Bates thought was a knife. And the injuries that Officer Bates sustained were the result of his own carelessness as he aggressively placed my client under arrest. Finally, ladies and gentlemen, my client has been charged with disorderly conduct, which requires he either have had the intent or acted in a manner to cause a breach of the peace, such as remaining in a public place after being instructed to leave by a police officer. And yet, in his own words, Officer Bates testified that he told my client he had to leave only if he was not a student, which of course he was. The state has categorically failed to meet their burden on every charge. Now, members of the jury, at the end of that story, the Queen of Hearts was only stopped when Alice stood up to her and pointed out that what she was doing was wrong. Stand up to the Queen of Hearts in this case, ladies and gentlemen. Find Andy Madison not guilty of these charges, because just like Alice in Wonderland, the prosecution's entire case is a fantasy. Thank you.